All right, we will be going live. All right, hello, this is Chris Berry, certified law attorney, certified financial planner with Castle Wealth Group, and we do these weekly wisdom webinars where we just go ahead and answer whatever questions you may have. Today I have a question submitted, and again, if you do have a question, feel free to put it in the Q&A, and we're happy to go ahead and answer those questions live as we go. But today, what I'm going to start with is a case study. And what the issue is so we have, let's say mom, and mom just set up an asset protection trust to protect against nursing home care. Because understand there's different types of trust. There's revocable trust that just avoid probate and control the distribution. Had a call with a client today that they have a revocable trust from 2013. And what it does, it avoids probate and outright distributions to the kids, and that's important. They had assumed that it was an asset protection trust. And we have a form of asset protection trust called a castle trust that as soon as you move the assets into the trust, immediately it starts this 5-year look back, where if you can make it 5 years without needing nursing home care, then everything inside of the trust is protected from that nursing home or Medicaid spend down. So understand there's different types of trusts, but in this case study, we set up an asset protection trust. And then the question is, from a financial planning standpoint, how do we go about funding it, and how should we go about thinking about investing it? And so what I'm going to do is share my screen and kind of walk you through the approach. Hit this button and this button. Then it goes there, and then I hit this, and then I hit that button, and now, give me a second. My Zoom is being slow. There we go. All right. So what we had in assets, and again, the idea here is if this is the individual, figuring out what assets should be in their name versus what assets should be in the trust. Obviously, the home goes directly into the trust. Now that it's starting that 5-year clock. But we had these other assets here. And this was actually a married couple, let's say, and the husband has dementia. The wife is still around and healthy, but concerned about long-term care costs. And they had some Bank of America. They had a lot of money in checking. They had a CD. They had an annuity that was out of surrender charge. They had a lot more money at another bank from selling of a second property. They had some life insurance. They had some other funds at another advisor. And what we decided, because we wanted to simplify things, we don't need all of this stuff out here. So what we did is we took a look at this from a financial planning standpoint of like, what assets should we keep? What should we be doing with the money? And I always like to, from a financial planning standpoint, look at kind of buckets. And so we have our now bucket of money is money that we might need over the next year. And we figured that with their expenses of being relatively low right now, only about $2,000 a month, their house was paid off, so everything was good there. They're concerned with the long-term care costs in the future, but they didn't have a lot of expenses. So, and also they didn't have a income gap. So their income coming in from Social Security and pension was covering their daily expenses. But we figured, you know what? Let's have that emergency fund of about 6 months worth of expenses. So for them, it was $12,000. And then also we looked to see what future expenses might we have over the next year. Do we have to fix up the house or do a new roof, or do we think we might need to bring in home care? So we figured let's put another, say, $50,000 worth of expenses just sitting in checking and savings. And so if we looked at the assets, we said, you know what, that Bank of America account, that's about there. And we don't need 2 banks. Right? There's no necessary reason for that. So we chose to keep the Bank of America account. So that's our now buckets. That's money sitting in checking savings. That should be the money that gets us through the year. Now, the rest of the money, we want it owned by the trust. We want the trust as the owner. The reason for that is when the trust is the owner, now with the trust as the owner, that's what builds in the asset protection, protects it from the $10,000 to $15,000 a month nursing home bill. And we like to break it into buckets. Think of it as years. So for kind of years 1 to 5, that money should be invested conservatively and geared towards income. And then the rest of it, we can look at investing maybe more aggressively or more geared towards growth. Okay. So what we decided to do is, since they already had this 9-month CD, we're going to call that soon bucket of money. But once that CD comes due, and that CD was only earning about 4%, so they locked it up in a 9-month CD for 4 months, when right now we have a high yield savings account that's offering 4.9%. It's completely liquid. So we're going to have that CD. Once that comes due, that's going to move into a high yield savings account. We're going to cash out that annuity, which it was a variable annuity, which just doesn't make sense these days. And that's going to be invested in a conservative investment at our custodian. And so we figured on the amount of $250,000 for, say, the next 5 years, because we figured, hey, if our expenses are, we want to have about $50,000 potentially of expenses, just as a backup, if we need long-term care, something like that. We figured we could move $50,000 a year if we needed to. So we figured, you know what, let's have 250 liquid available to refill that now bucket each year. And then the rest of the investments can be more geared towards growth. And so we're going to cash out the money sitting at the bank and move that over into more of a growth portfolio versus the conservative portfolio, so that then as that soon bucket gets depleted, we can then move the money over here from that later bucket. The idea is we want to make sure we're keeping up with inflation, because especially having all that money sitting in just cash, you're not even keeping up with inflation. I know they say inflation's coming down, but I look at the price of a meal these days and it's like double what it used to be. So I'm not completely sold on that. So yeah, so at the end of the day, we have $100,000 sitting, kind of roughly 100,000 sitting in cash, checking savings. And then the rest, let's say 250 plus another 350. I can't do math in my head. That's going to take us about 6. The house, and then about 800 will be protected in the trust. And again, the purpose of the trust is, as soon as the money moves into the trust, it starts that 5-year race, because Medicaid has a 5-year look back period of, once you make it 5 years, 100% of what's in that trust is protected from that nursing home or Medicaid spend down, because nursing home these days can cost $10,000 to $15,000 a month. So hopefully that was helpful. It's just a little case study of how we set up the trust, and then B, looking at making sure the trust is funded properly. Not all the assets necessarily need to be in the trust. All right, let me see what questions I have. All right, now let me get to my next one. And again, if you do have a question, feel free to put it into the Q&A. Otherwise, I'll get to answering this next one. Give me a second, share my screen again. Oh, and I forgot positive focus. I always start these with positive focus. Just got back from a vacation with my family, my wife and kids in the Bahamas. So it was great. They got to swim with the pigs, which is kind of funny. All right. So here's the next question. So I want to give away my inheritance to other beneficiaries. I do not want to disclaim. Must I have an accounting of the value of the estate before or as part of the agreement to alter my shares to the specific beneficiaries? Does the probate court require that I know the amount I am giving away? I'm okay with no accounting, understand the tax consequences. Okay, so there's a couple things going on here. The first thing is we have this word disclaim. So if I'm understanding the question, here's a situation. We have someone, fortunately, they've passed away and they've left things to these different beneficiaries. And I'm not sure if it's through a trust or through a will or through a probate. But let's say one of these people says, you know what, I don't want my stuff. Maybe I want it to go to the other people for whatever reason. One thing they can do is they can disclaim. And what disclaim means is it acts as if that person has passed away, and now their share would typically flow down to their beneficiaries. But it sounds like what this person wants to do is not have it go down to their heirs, but instead have it go to the other beneficiaries. So if the person already passed away and is now inheriting it, your first option is to disclaim, but again, that's going to go down to the other beneficiaries. Really, the only way at this point, if the distribution has already happened, I guess there's two routes. If the distribution has not happened, you could go to probate court and petition the court to kind of do that. That's going to be kind of a pain in the butt. The other option is you can just receive the inheritance and then you can gift it to the other beneficiaries. Okay, so this would just be an outright gift. Okay, that's really the only other way to get it there. Is you covered? Are you covered? Okay, I'll get to that question. So, must I have an accounting of the value of the estate before it was part of the? Okay. So really, it's not a probate court thing at this point. It's not an accounting or estate issue. Really, there's no issues there. So to answer the question, does probate court require that I know the amount I'm giving away? No, probate court doesn't really care. It's already outside of that process. Must I have an accounting of the value of the estate before? No, you don't have to have an accounting or anything like that. The only thing is really just the tax consequences, and it says that you understand the tax consequences, but really, if you're gifting more than 17,000, which is the annual gift tax exclusion, then all you have to do is fill out a gift tax form. So that's really the only accounting that would be necessary. Is if it's like $50,000 that you're giving to someone else, then that's greater than your annual gift tax exclusion. Now, if you're married, you can double it. So there's some things you can do there. But your annual gift tax exclusion for one individual is 17,000. If you gift more than that, then you fill out a gift tax form to notify the IRS that you've made a gift. But it's typically going to still be gift tax free because you also have a unified credit, meaning as long as you die or give away less than $12 million during your lifetime, you owe zero gift or estate taxes. So really, this isn't like a probate or estate question per se. It's more of a tax question. And at the end of the day, it's probably no big deal because A, you can either use your annual gift tax exclusion, or B, you can fill out a gift tax form. The only time it gets kind of tricky is if you're trying to like give away like IRA money. Like, unfortunately, you would have to pay the tax on it, because to take it out and give it to someone else, you would have to pay the tax. But if it's something that's post-tax or if it's personal property, then that's not a big deal. So this would only get a little bit tricky if it was IRA money. So hopefully that helps. All right. And then here's a question that just came in. Are you covered if you have over $250,000 in one bank account? Should it be split out to different banks? IRA, age is 89, no spouse, account is in owner's name, but do have a trust. Thank you. Okay, so the question is asking if you have over $250,000, should you split that up amongst banks? And what the person's trying to get at is, like, if the bank goes under, that's where your FDIC coverage is at. You certainly can. There are some, like our high yield savings account that's paying about 4.9%. That has, I think, over $1 million of FDIC coverage. So understand that depending on how the banks are set up, they could have different amounts of FDIC coverage. I would recommend that you only save up to the level of that FDIC coverage, which typically is 250. But again, we have a high yield savings account that's over $1 million. So yeah, that would be a situation where maybe you want to split it up amongst different banks. IRAs, that doesn't, I wouldn't split up IRAs. you don't have FDIC coverage for that. All right, so hopefully that helps. All right. Another question, if I put my Roth into a trust account, does a 5-year rule come into play? Yeah, so you can't put your Roth directly into the trust. What you would do is you would take the money out of the Roth, which is tax-free, and then you would put it in the trust, and that'd start the 5-year clock. So again, you want as much as possible inside of the trust. All right. Let's see. Any other questions? Going once, going twice. All right, sold. All right,